Welcome back, everyone, to our video series. HospitalityLawyer.com is happy to visit with you today about extended stay issues. But before we get into the substance, I just want to gently remind everyone that we cannot provide you legal advice. We're here to give you information, education, and potential insight. But as the law changes from state to state, sometimes even as often as locale to locale, we always suggest that you contact your local legal counsel for guidance in these matters. So let's meet the two thought leaders in the hospitality law space that are joining us today. Mr. Greg Duff is a principal at the Foster Garvey law firm. Greg's practice is a nationwide practice. He focuses on all aspects of hospitality along with his team there at Foster Garvey. He is franchising, management agreements, food and beverage aspects. Greg also is one of the few lawyers in the country in private practice that really understands the operational aspects of hotels and restaurants. So we're happy to have Greg join us. Welcome, Greg.
Thank you.
Joining Greg today is Justin Bragiel, General Counsel, the Texas Hotel and Lodging Association. In Justin's role over there as GC, he comes across just about every aspect of hospitality law that one might imagine, and he has handled all of them deftly. Even before the pandemic, he was the go-to person in Texas for any challenge that a hotelier faced. Certainly during the pandemic, he was the guy, and we've been fortunate to have him in Texas leading the way. So please welcome Justin.
Thank you, Stephen.
Hey guys, so, with COVID, there seemed to, even before COVID, there seemed to be a trend of more hotels, not just the ones specifically developed for long-term stays, but more hotels having guests stay longer, right? And so we think it's important that we kind of talk about that. But are you seeing that as well? Are you seeing your clients and your members having more long-term stay guests?
I'll jump in here. I would say generally, yes. I think this may be reflective of the phenomena that also is seeing the tremendous growth in alternative accommodations. If there is a desire to have an accommodation for a longer period, as you said, Stephen, though, COVID and everything associated with it, I think has only accentuated that. The other factor I would add, at least for those of us in the Northwest, for example, is the current state of homelessness has also contributed to this, where you may find a guest who might check in for a day or two and only afford a day or two. Suddenly they start staying longer, or they view a hotel as a form of residence, and maybe they are a 30-day guest or longer, but they're now using hotels for residential purposes where perhaps maybe they didn't in the past.
Yeah. Justin?
Yeah, same, and some of it I think is driven by hoteliers that are stretching into different areas of the market as business demand remains somewhat suppressed. We're seeing that, and some travelers' patterns have changed. Maybe they want to go work in a different city for a while, or work in a different area for a while, and are engaging that extended stay. Greg, we're seeing it here even in Texas too, as far as homelessness goes. And certainly an increase in that trend. It's happening. I think it seems like everywhere.
Yeah, and look, I want to remind the audience before we get too far down the road that this is a very challenging situation to talk about legally, because all 50 states, even they're certainly different, but it could also be different from city to city within a state, depending upon the local ordinances that have been passed. So we want you to know we're going to talk about this generally, but as I mentioned previously, if you get yourself in a situation, a delicate situation, it's really important that you get some local guidance on how to manage that. Certainly the two gentlemen joining us today can provide that some specific guidance in their space and their scope of expertise. And if they can't, then I'm sure they'll be able to suggest somebody that you can speak to. But it is important that you keep that in mind. All right, look, before we go too far down this path, Greg, I think it's important that for the audience, we establish what a guest is. So, my understanding is a guest is somebody that's there for a lawful purpose. Does that ring true to you?
It does. It does. I think this entire discussion should be premised around the fact that, we had someone on the property as a guest, as you said, for a lawful purpose. Presumably they had a booking or a reservation that had certain terms and conditions associated with it. And now we're talking about the status of that otherwise lawful guest as he or she continues to stay on the property.
Yeah, and then to be sure, we could have a guest of a guest, which they're there for a lawful purpose, right? We could have that.
Yes.
But can we all agree that if somebody's not there for a lawful purpose, then I think the law would classify them as a trespasser. Is that fair?
I think generally it is. When we talk a little bit about some of these moratoriums and creating some of these unintentional tenancies, which is what I might call them, they may not have necessarily started out as a lawful guest, or perhaps they might have looked as one, but we have instances of where people had just shown up on property and made their way into a room and then claiming their tenancy status. So I generally agree with you. There are some, I think, fringe examples of where that may not necessarily be true.
Wow, that's an interesting thought. I hadn't considered that type of scenario. Yeah. Well, Justin, but if somebody's there to sell drugs, if somebody's there for prostitution, if somebody's there for human trafficking, I think we would agree that those people we would classify as trespassers with Greg's caveat as part of that equation.
Well, I think that's right, particularly if they're engaging in otherwise unlawful activities, such as, engaging in drug deals and whatnot. Clearly, there's a criminal element there too. I mean, I think, it may be worth emphasizing there's maybe a difference too between a guest and an invitee. Typically when I think of a guest in the hotel context, there's a meeting of minds, a contract essentially formed between the hotelier and the individual who's there for accommodations. That's typically, if we're talking about, the extended stay versus transient context, that meeting of the minds, the contract, the license to use the hotel space for the period of time is part of it. Otherwise, if somebody wanders in off the street, but they're not engaging in otherwise unlawful activity, I don't think they fit quite within the category of being a guest, but they very well may be an invitee until they're told that they can no longer remain on the property by the manager or owner.
That's a great distinction. Thanks for sharing that. Well, so you mentioned, let's break the term guest down a little bit more, right? Because that's going to play a big role in this conversation, because typically and historically, hotels have rented to transient guests, right? People there for a short-term stay, not intending to make it their residence. But then when we get into this long-term stay discussion, I think we have to distinguish those transient guests from tenants. Does that sound like we've set up the challenge, Greg? The transient guest versus tenant?
I think so. Yeah, and I'm sure we're going to talk about this, but that line as to where one transitions from the transient to the now residential tenant is murky, and one where I'm sure that Justin, in his experience and our experience, that's where we live, and trying to draw that line one way or the other.
Well, let's talk for just a minute from y'all's perspective and what you've seen. Why is it important for an innkeeper to know the difference, or at least to have some understanding of the difference? Justin, you want to go?
Sure. Well, I think, primarily there are many more rights that attach to a tenant than a transient guest, right? And we think about the basics of property law, back to law school, right? A tenant is somebody who's received a property interest from the owner of the land. They actually have the right to exclude others, and with that comes all types of statutorial protections and maybe some case law protections as well. But in most cases, states have codified the rights of a tenant and really codified the relationship and the resolution of disputes between a landlord and a tenant in whatever the relevant property code is for their particular state. But in a tenancy, or I should say in a true guest scenario, a transient guest scenario, for the most part, that's not defined in the law, or at least not in statutory law. And instead, we really, for the most part, fall back on just plain old contract law to determine how to resolve disputes between the owner of the property or the manager of the property and a person who's using the property. We typically look at this as, if somebody doesn't have a lease agreement with the owner, that person has a license instead, a contractual license to use the property for that period of time. And so we're going to resolve any sort of dispute there. I mean, I guess ultimately, if it goes as far, via the civil courts process through a traditional lawsuit for breach of contract. Whereas if we have a tenant, we'd be going through, at least in Texas, the justice of the peace courts, but could be a variety of special courts that are typically set up to handle disputes between landlords and tenants, with all kinds of additional waiting periods and notice requirements and everything else that doesn't attach. The transient guest, we enforce typically via criminal trespass if there's some sort of an issue there. It's really a different world. But I think what Greg and I are going to talk about here is what's blurred now in the era of COVID. It was always blurry, but now it's really blurry.
I would only add to that is, the self-help remedies which exist in the transient guest side are there's far more many self-help remedies that one can pursue with the transient. On the residential side, as Justin mentioned, it's largely dictated by statute. And not only does the statute sort of govern the relationship, but from an operator-owner perspective, that statute also many times will spell out the statutory remedies and damages that the tenant is entitled to should you proceed contrary to the statute. So you may have gone from a scenario where, hey, I'm going to just trespass you or lock you out of your room or whatever, in which case I would say the potential damage in that scenario should be rather minor, to now you're under a statutory framework where the statute's not only going to govern what rights and remedies you may have as the landlord vis-a-vis the tenant or vice versa, but now we have a scenario where the courts are also going to impose statutory remedies on you, the hotelier, for failing to follow those processes. And in some states, they can be rather steep. So it's an order of magnitude, I would say, as well as we cross over into the residential tenancy. You need to take that individual perhaps a little more seriously and carefully than you would otherwise.
I think that's a great point. And Justin, I think you alluded to this. The rights of privacy of the person or the person that's classified as the tenant are much greater than the transient guest.
Oh yeah, absolutely, and there's even the expectations are different too, right? Even where oftentimes a typical lease agreement, maybe for a traditional apartment, will contain clauses that allow, say, maintenance personnel to enter an apartment. Typically, they have to provide advance notice and whatnot. In the hotel context, it's entirely different. I mean, I would argue not only do we have the right, but really the obligation, particularly in a post Las Vegas world, to regularly enter hotel rooms to ensure that that all is well inside that room. Of course, to protect our own hotel property, but the welfare of the guest. And I think the expectation there for guests is that we do that when you check into a hotel. Even when you decline daily housekeeping, there are individuals from the hotel, personnel from the hotel that are going to enter that room regularly. And in a transient guest context, the guest really has no right to refuse that. I mean, certainly we would arrange the visit and be respectful of the physical privacy of the guest in that scenario, but I don't think they have the right to refuse it. Whereas in a landlord-tenant relationship, oftentimes that is the case. And there are some state laws too that even specify, the frequency by which an individual landlord may enter a unit.
I would add one more element to this, which is also critical from the hotel owner operator perspective, in that how you classify that guest as either transient or residential also has important tax implications in terms of occupancy taxes and other things like that. So, and I know we're going to talk about how we characterize one or the other, what the factors are, but where you come out on the analysis not only is affected by what we've discussed thus far, but it also has tax implications as to whether or not you as the owner or operator need to be collecting those types of taxes or not. So that's another important element about looking at the differences here and what it might mean for you.
Yeah. You know, guys, I haven't seen a case around this. Perhaps you guys have, but my impression from reading the innkeeper's limited liability statutes, there's 50 of those across the country as well. But my experience with those is they typically reference guests.
Yes.
Transient guests and not tenants. So I would worry if somebody morphed into a tenant that perhaps I'm also losing that protection. Now, as I said, I haven't seen the case, but you guys, I think that could be a pretty decent argument for a tenant to make. You guys think so?
That's an interesting aspect. I hadn't thought about that. I mean, ideal, I guess in theory, if we've got a tenant, it's the lease that would govern that sort of arrangement rather than a statutory framework.
Right.
Well, and that's interesting, Justin, because so let's move into how do we determine if somebody's a guest or a tenant. And one of the first things we would look at, I think, is the format of the contract, right? Because can you distinguish those, right? In a hotel?
Well, and I guess, and again, it's so like just for Texas, for example, remember a lease agreement can be oral. It's rare, but it can be. But just keeping that in the back of your mind about having to prove things up, right? But yeah, I mean, I think it's really about the meeting of the minds and where the minds met, right? If we have a sort of a traditional hotel and format, as far as what the hotel looks like, what their typical guest scenario looks like, and a guest walks in off the street, and even when he or she books an extended stay, maybe more than 30 days, 60 days, 90 days at a time, if there's not a meeting of the minds that these parties intended to establish a lease agreement, I still think we're in the transient guest relationship here, because nothing has indicated to me that the parties intended to form a lease agreement and to establish a leasehold agreement. But of course that's where the meat of this conversation is, right? Are we there yet or not? But I think what the parties intend is really critical here. And remember, it takes two to form a contract. So and a lease is a contract as well. So what did the two parties intend when they checked in? And then we look at other factors to try and make a determination as to what those two people intended. And some things that the courts have looked at, mostly state courts, but the states have looked at in the past are things like just the length of the stay. With the longer the stay, maybe tending to lean more towards we have a landlord tenant here. Whether or not the individual that's staying there considers and by the way, none of these factors are decisive on their own. This is like a preponderance, or just we look at them all in totality. Whether or not the guest considers this to be their now primary residence, and we'll look at whether or not they get their mail there or other items delivered there. Whether there was any sort of written document establishing some sort of a promise to stay for a minimum threshold, or deposits oftentimes will come into play. So those are some of the things that the courts have looked to. Here, at least in Texas, though, the default position from the litigation side has been that if it's a traditional hotel, that's typically what the hotel deals with is transient guests. That's what we're going to assume, unless there's really some sort of evidence that the two parties intended to establish a leasehold. But you got to get there. That's so rare do we actually get there. We're dealing in the here and now. If we've got a guest in our, who's holed up in the room who hasn't paid their bill, and what do we do? That's where where I tend to live.
Yeah, no, for sure. Greg, any other thoughts about that?
Yeah, I was only going to add that, length of stay tends to be a litmus test of sorts, because a lot of residential tenancy statutes are written to apply those of 30 days of continuous occupancy. And so our advice often in those states where you have a statute like that is, if you can keep the tenancy or the occupancy at 29 days or less, and only accept reservations for that period or less, and do those kinds of things to avoid that sort of 30-day threshold, that, at least in our experience, goes a long way to establishing and maintaining their status as a transient and not as a tenant. So in many instances, in many states that we've looked into, that 30-day line tends to be sort of a bright line test, not determinative. I agree with Justin on that point, but it tends to be sort of a line that we encourage people to try to avoid crossing.
Hey, and I got a question for you guys. If you know, maybe you answer this, Greg. So I know there's one extended stay brand that tends to have a document that they have the guest sign that indicates that the guest agrees that they're not establishing a leasehold agreement. I think that's helpful evidence. I don't know that it would necessarily be the be all end all. Have you seen that? And have you any experience working with any of those particular types of documents? Those tend not to be our members, so I don't really get hands on with that too often.
Greg may have drafted that document, but
yeah, that's why I'm asking, right? Ask the expert.
So I know the one that you're speaking of, and I was quick to learn that apparently only really works in Texas. So that's
okay. Well, there you go.
So I have seen that document. We have created versions of that, and I will tell you that in the last 18 months, we have tried to create several varieties of that to avoid application of residential tenant eviction moratoriums.
Sure.
Just simply to try to avoid application of those things if they're not expressly applicable. And I have actually had conversations with state attorneys general office about the use of those, and every one of them gave it a good chuckle and said, this is by no means determinative of anything. So if you want to say this, have at it, but I don't think it's not going to win the day in court if I ever come after your property for using it. So
yeah, that makes sense to me.
No, that's a great point, because, we learned that with classification of employees, right? You can tell an employee all day long that they're not an employee, but if it walks like a duck and talks like a duck,
absolutely,
it's pretty well a duck, right?
Exactly.
So let me get back to this 30-day thing just very quickly, because, and Greg, I agree with you on the litmus test thing. That does seem to be the thing that is kind of prevalent in these conversations. But here's the question. Is the innkeeper, if somebody does stay there 30 days, do they absolutely have to exempt that guest from occupancy taxes going forward?
It's typically by statute. So
okay.
Whenever there is this exception to the occupancy tax that's been created, it usually is statutory or at least regulatory. So in Washington, for example, it's quite clear that you don't have to treat the resident or one who's been there for 30 days. You don't have to treat them as the transient guest for purposes of collecting occupancy tax. In some states that we've looked at, it's not quite as clear, but fortunately we live in one here that is very clear on that point.
And I'll give you the opposite side of it. And here in Texas, at least from the Texas Comptroller's office, it's considered a right of the guest, regardless of sort of how you structure that stay. If there's the stay in the hotel building is continuous, then the guest is entitled to that exemption. But that may still be helpful for the purposes of this conversation, right? Where we're talking about in this situation where we want to avoid a landlord-tenant relationship. Here we can almost take advantage of the best of both worlds, exempt the guest, but still not use that as evidence of that they necessarily are a tenant. I don't think it would be right to say that every time you have a guest that's exempt from hotel occupancy taxes because they stayed more than 30 days, that they become a tenant. We certainly don't think that's the intention of the, and it's a different chapter of the law, right? We're talking about the tax code for this and, and landlord-tenant law in a different section, typically. So, but it's interesting if that's the case. And in fact, our attorney general has gotten aggressive in the past against hotels that were engaging in this sort of activity where they were checking guests out on the 29th day and then checking them back in for the purposes of avoiding a landlord-tenant relationship, but at the same time not honoring the hotel tax exemption and basically saying, no, you're engaging in a practice here that's harmful to consumers and you need to stop that. So I think tread carefully as far as taxes are going. I think would be my advice.
Yeah, I would say we've had a couple of examples of where the issue of whether taxes were collected or not was one of many factors you consider for a transient or not. And so it went to the hotelier, what was your expectation if you weren't paying or collecting the taxes? You clearly thought they were exempt, and therefore that's in favor of their residential status. So I think you have to be careful. Not only is it nice to extend that benefit to your guest, but it can be used against you if later on you say, oh, no, they're a transient. It can be used against you. So be careful.
It's one of those determining factors, right? That they'll look at. And my experience is courts tend to give some pretty significant weight to whether or not they're being charged the occupancy tax or not.
Yeah.
I'm not saying it's the end all, as Justin said, it's not, the end all, but I do think it carries some weight there. So, and as Justin pointed out, is Texas, and I'm sure other states have come to this conclusion, we've all been talking about, we'll just check them out on the 29th day, right? Check them back in, make them change rooms. But I think Justin just pointed out that a lot of the courts and the attorney generals have gotten kind of savvy to that practice, and they're saying no, if they're in the building, right, then they've been there longer than 30 days, that they have the right to opt out of that occupancy tax. Justin, did I kind of get that right?
Yeah, you did. And it's not even the right to opt out. It's our language in the code says the tax shall not apply. Right.
Oh,
so it does not even apply. So I think for a place like Texas, maybe we got to avoid some of the problems that they're seeing in Washington State. If I think it'd be hard for an individual to say, look, the property chose to exempt my taxes here, and so therefore they intended for me to be a tenant. Well, here we say, no, we didn't choose. Tax just doesn't apply to you.
Yeah, that's a great distinction. Yeah, I'm glad you shared that with us. Thank you. Well, Greg, so I know you've brought this up now, and I want to visit about it before we wrap up, but these eviction moratoriums, how does all of this play out with those?
Well, whatever you thought you knew beforehand, you can throw it out the window.
It helps because I didn't know very much.
Oh, that's the reality here is even if you think you have a good grasp of trying to discern between guest and residential tenant, and maybe you think you have a good grasp of the applicable statutory provisions with these new, so in Washington, we both have state eviction moratoriums, and in the city of Seattle, we have a mayoral issued proclamation also prohibiting evictions. And it sort of turns everything that you might know on its head. So for example, early on in the pandemic, Washington State, the governor issued a proclamation prohibiting evictions. And in that, they reduced the period of time. I think it went from 30 days to like 14 days, for example. And to test that 14-day period, we had many conversations with the state attorney general office, with those that were charged with enforcing this, to say, are the same rules that we might apply to the 30-day, for example, and some of the tactics like Justin, you mentioned about, okay, there's no guest that's going to stay in a room longer than 13 days, and we're going to check them out, we're going to check them in. All of these practices that hoteliers might have engaged in previously for the 30-day analysis, can we use similar tactics here to avoid the 14-day, and are those effective? The resounding response to everyone we spoke with was no. You're playing games with this. The intent here is to avoid putting people on the streets during a pandemic and putting them in a position that they're likely to contract the illness or transmit the illness. And so every possible interpretation that we can find of this proclamation that favors keeping the individual in the room, that's how we're going to approach this. And in Washington, they went so far as to deputize many different private attorneys in the city of Seattle and elsewhere in Washington, whose role at the time was simply to come after landlords for violating the moratorium. So you have that structure that's going on. And then in some jurisdictions, I know they had this issue in California and we had it in Washington, which is there are many tenant rights organizations that have been in existence for years, but now armed with these eviction moratoriums, they became very, very active and very proactive in actually distributing materials to people in hotel rooms, advising them of their rights to remain in the hotel room. And then if the hotelier did something contrary to that, they were persecuted publicly through press releases and newspaper articles and television news and other coverage that, frankly, for many of our guests, because of them, ran the other direction, simply not wanting to run afoul of them. So it has had a material effect on guests' willingness to stay longer, and frankly, many stopped paying on that 30th day, ironically. So it's created that scenario and created the likelihood that more of these, but it's also, I think, caused many hoteliers just to take a step back and say, I don't care what my practice has been with the traditional analysis. I'm throwing that out, and I'm just not going to touch these people for as long as these moratoriums remain in place.
Justin, have you similar experiences?
Yeah, maybe not quite as extreme, but very much a patchwork, because we're a state that ended the statewide eviction moratorium, and really, for the most part, our governor has prohibited local entities, local elected officials from doing much here, but that hasn't stopped local officials of a different party from enacting their own eviction moratoriums in defiance of the governor's order. And so, remember, folks are elected locally, right? So the county judge is elected in the county in which he presides, and JP judges are elected in the precincts in which they preside, right? And so, and that all trickles down from the police department to the sheriff's deputies, anyone doing any sort of enforcement, right? So, so even in a conservative jurisdiction overall, like Texas, in larger metros, for example, you may have a scenario where 2 years ago, it would have been very clear. You call the police department out, say, I've got a guest who's refusing to leave. He's a guest. He's been here a while, but he's a guest. He's not a tenant. And the police just say, no, there's an eviction moratorium. We're not touching it. There's an eviction moratorium. Well, hang on. That eviction moratorium isn't lawful, but we don't care. That's not our problem. See you later. Go to JP court. Go to JP court and say, we have a local eviction moratorium. Well, that's not lawful. Well, okay, it's challenging. It's real challenging.
It is challenging.
And to add on to that, the one thing we've also found, this I think to your point earlier, Justin, even in scenarios where we felt confident that the individual was still a transient guest and that we would otherwise have the traditional self-help remedies of locking them out or trespassing, what have you. In one instance, for one hotelier, for whatever reason, they had multiple of these. We went to local law enforcement, and with several of these individuals, the local law enforcement confirmed that, oh yeah, we've been watching these individuals for a long time for criminal activity. One actually had an outstanding warrant, believe it or not. But in each instance, the local law enforcement, because of the existence of the moratorium, said, we're not touching it.
Yeah.
Really sorry, would really like to help you, but there's too much uncertainty as to how this is being applied that we're just not willing to help you.
Yeah, it's going to be challenging. Gentlemen, I guess the moral of the story is, if at all possible, get your money up front, right?
Yeah, hopefully a lot of it to cover a lot of time they hold over. Yeah.
That's true in a lot of contexts, Stephen, whether it be group sales or anything else.
Yeah.
Right.
Get your money up front. Well, ladies and gentlemen, thank you for joining us today. I know we weren't able to provide a lot of clarity, but I hope we provided some of the challenges that you are facing and are going to face. And this is a touchy situation, as both of our speakers have presented to you today, and for the reasons that they discussed. And keep in mind that it's, as they pointed out very clearly, it's different in different jurisdictions, and you must be mindful of that. Whether it's just the plain, are they a tenant, are they a guest, or is the eviction moratorium going to create some clouds on the horizon for you? You have to be very mindful of that these days. So I know it's tough out there. Best of luck to you. I'd like to say a special thanks to both Greg and Justin for sharing your time and expertise. Thank you both as usual, and we'll be in touch for another topic before long.